And good morning, everyone, and thanks for coming to our drafting group meeting for the Justice and Municipal Courts. We have a new member here with us, Melissa France, and for the benefit of Melissa, we'll just quickly go around the squares and briefly introduce ourselves. Then I'll go through the agenda and we'll talk about what we're going to try and cover today. And then I'll be doing some screen sharing as we go through the issues. My name, Melissa, it's nice to have you here. I'm Rebecca Duncan. I'm a justice on the Supreme Court and a member of the Law Commission. And I am co-chairing this group with Krista Obel-Eshelman, and we're glad to have you here. And John Henry Hinkson, I see you next to me, so I'll let you introduce yourself.
I'm a criminal defense lawyer from Oregon City, and I've been practicing 51 years, and I have retired.
All right. We'll just go on my screen. Victor.
Good morning, Victor Ruther, staff attorney with Legislative Council.
Great. Krista, you're in the middle of my screen.
Hi, Krista Obel-Eshelman. I'm one of the commissioners and co-chairing with Justice Duncan, and I'm a juvenile law appellate attorney with Youth Rights and Justice.
Judge Gill.
All right, Ms. Franz, good morning. Greg.
Good morning, Your Honor.
Good morning. I don't think we need to have any other introductions.
Oh, okay. Okay. And then our last two members here are Jim Nass and Jessica Menefee, and I just want to call them out. They have done a great deal of work in getting us to this point where we are. They prepared our working draft that we have, and Jim has done a lot of background work and given us our documents explaining how the draft works with the existing statutes. And so I'll let Jim and Jessica introduce themselves, but I did want to call out their contributions to our project. Jim.
Thank you, Justice Duncan. Jim Nass, former appellate commissioner, Oregon Court of Appeals, now retired.
And Jessica.
And I'm Jessica Menefee. I work at Legislative Council.
And Melissa.
Well, thank you, Justice. I probably recognize about 7 people on this Zoom meeting because of my work with the Judicial Department. Just for everyone's knowledge, I used to work in the Office of the State Court Administrator for the Judicial Department. And I used to work on Senate Bill 896 appeals work group when that was going on. I moved over here to the city prosecutor's office in Eugene in 2019. Judge Gill is our presiding judge here in Eugene. I actually recognize Sandy from, I used to work in the conflict resolution program over, I used to clerk over there at the U of O. And then I also worked under Hillary Berkman in Office of Student Advocacy when I was at the U of O as well. So I do recognize quite a few people. Jessica, you're a saint for doing all the drafting on this. The only people I didn't recognize was Mr. Ruther and Ms. Eshelman, but I'm sure we'll get to know each other very well. So yeah, I'm an assistant city prosecutor over here in Eugene, but other than that, I'm glad to be here. I'm happy to participate. Thank you.
Thanks for joining us. And it's great that you worked on the last appeals bill because you'll be familiar with what we're talking about. I'm going to share my screen now, and I'll go first to an agenda and go over that with you, and then we'll dive into some of the drafting questions that we'll be covering today. I want to share this screen. Okay. So I'll just go over the agenda first. I apologize for not sending this out in advance. I know everyone's really busy and I just didn't have enough time to do everything that I wanted to in advance of this meeting. So I appreciate your understanding and patience. So today's agenda, I'd like to talk about the drafting approach in general for this project. And then we would like to go over certain procedural issues. And specifically, we'll start with notices of appeal and the deadlines for those notices of appeal. We'll review the current law. We'll talk about what's in the draft. We'll go through four questions, 4 issues about the deadlines for notices of appeal so that we have answers to or preliminary answers to some questions about what those deadlines are and what we might suggest that they should be. And then time permitting, and I hope it will, we will also talk about additional procedural issues related to notices of appeal, specifically who it has to be served on the notice, what's supposed to be in the notice, where is it filed, and if we have time and energy, we may get to some questions about the records. So what is the appellate record for these appeals? Who creates it? Who files it? There are other things on the horizon which we won't be taking up today. Those include the statutes relating to stays and undertakings. And we will not be talking today, but we will be talking in the future about the bigger, perhaps bigger policy issues about what issues are appealable by whom and at what point in a case. But today we're doing some of the kind of hopefully not too complicated issues about just the mechanics of bringing an appeal from a justice or municipal court. So what I have been doing since the last time this group met is going through all of the statutes, and as we've talked about many times, they're scattered throughout the ORS chapters. But I think as a foundational idea, what the statutes reflect and what might guide our work group is the understanding that there's basic procedures for bringing appeals that the legislature has created under current law. The kind of building block of these appellate procedures is set out in statutes governing appeals from circuit courts in civil cases. So that's the basic framework. And then it gets modified a little bit when you have criminal cases from circuit courts. And then it gets modified a little bit more when you have appeals from justice and municipal courts. But if we start with the understanding that these appeals should be as, the process for them should be as similar as possible, we can use the process identified for civil appeals from circuit courts and make it as similar as possible for all of these other circumstances. So that's one idea that kind of is at least guiding my approach to this work, and you'll see how that plays out. And the other thing I would note at the outset, as we've all talked about before, there's 2 categories of justice and municipal courts that are relevant to whether something is or how appeals are done. And that's whether or not the justice or municipal court is a court of record. If it is a court of record, pretty much the appeal is treated like it's coming out of a circuit court. And Jim and Melissa and everyone who worked on the prior appellate project of the Law Commission already addressed like the process for those appeals. And so those are less of our concern. Our primary concern, we do have to make sure that those statutes still at least fit for justice and municipal courts. But our primary concern are where the justice or municipal court is not a court of record, because those processes are unique, and they might very well be unique because of just the differences between the courts of record and not of record. So those are some kind of principles that I'm keeping in mind as I approach this. And as I mentioned, we're going to focus today on some of it, I'll just call it the nitty gritty, and particularly the nitty gritty about notices of appeal. I'm going to change screens here for a second and call up a spreadsheet. You cannot read this. I don't want you to try and read this, okay? It's too small for you to read. It's too small for me to read on this screen, but I want to tell you conceptually what this document is. You've received this document here in emails before, everyone except for Melissa. And so earlier in the project, I'm just going to describe it. You don't have to try and decipher anything on the screen except what's colored. So at the top, you'll see it says in yellow justice courts. I'm going to see if I can blow that up a little bit. All right. So it talks about justice courts, and then for justice courts, we have justice courts where there's criminal actions, violation actions, civil actions, small claims actions, and then similarly for municipal courts, we have all these different types of cases, and within each type, there are statutes that govern how you appeal, and they vary depending whether or not you're a court of record or not a court of record. So what we did earlier in this project is go through all of the statutes and say, okay, what's the existing rule for this type of court and this type of case regarding everything that's in the blue column. So that's the timeline for the notice of appeal, and I'll zoom in on that. All right, so everything over here, what's the timeline for the notice of appeal? Who has to be served? What are the contents of the notice of appeal? Who is it filed with? Who creates the record? What is in the record? And who may appeal, and how is the appeal perfected? So we have different statutes for all these different types of cases. And we have this spreadsheet that kind of sets out what the current law is. So what I did from our last meeting till today is focus on the timeline statutes, so we can talk about those. And that is a different page on this spreadsheet, which isn't going to be any more readable to you, but I just want you to know that we have this as a resource, and I'm going to try and figure out how to size it so we can get it to you on paper or some readable form. But the gist of this is that I've reviewed, like Jessica and Jim reviewed before me, all of the statutes that govern notice of appeal in all of these different circumstances. And that work leads me to bring 4 questions to this group today about notices of appeal, and we can talk about these 4 questions. Okay. So we'll talk right now about what's the current law for notices of appeal. So for almost all cases coming out of any type of court, circuit, justice, or municipal, we have a 30-day timeline for filing the notice of appeal. There is an exception for small claims courts, and that is for small claims cases, and specifically small claims cases in justice courts. There's a statute that says for those cases, it's a 10-day notice of appeal. So that's the current timeline. The statutes also vary in how they describe the triggering event for when that 30-day clock starts to run. Most of them say entry of judgment, but the older statutes talk about rendition of judgment. And so that is something that Jessica and Jim confronted, and we'll talk about that. But that's the current state of the law, is we have some statutes that say entry of judgment and some that say rendition of judgment. The other thing, letter C here, talks about deadlines for cases in which there has been usually it's a post-verdict motion, but a motion for a new trial, which is not necessarily post-verdict, but a motion for a new trial, a motion for a judgment notwithstanding a verdict, or a motion in arrest of judgment. So what you need to know about those notices of appeal is in cases in circuit courts, there's special deadlines. So it says if a notice for a new trial has been filed, here's the deadline for the notice of appeal. I didn't see, and maybe Jessica and Jim, when we get to the discussion of this, I didn't see a similar provision for appeals from justice or municipal courts. So we can talk about that issue. And then the 4th current state of the law issue here, I didn't see in the justice and municipal statutes any late deadlines for civil commitment cases or criminal cases. And we can talk about that. Whether Jessica and Jim know of any, I didn't see any, and we can talk about whether there should be, but it does not appear that there's any late deadlines like there are in circuit court cases for those categories of cases. So let's talk about this first issue, which is, what should the deadline be for filing your notice of appeal in an ordinary case from justice or municipal court? It's 30 days in almost all cases. And the exception that I mentioned is the 10 days for small claims. So I'll maybe start with an easy question, which is, does anyone see a reason why it should be anything other than 30 days, setting aside small claims for the moment?
I think there's one other category of case. As I recall, in civil cases in justice court, generally the appeal limit is 10 days only, which is why I suspect that the appeal period in small claims court and justice court is also 10 days, since those are all civil cases.
Okay, so
Wait,
Jimmy,
I'm trying to figure, I'm trying to track that, Jim. I'm sorry. Because there's a 10-day period on the small claims and in justice court. You figure it's 10 days where else?
No, I guess my recollection was that in civil cases, generally, the appeal period is 10 days. Is it not?
I think it's 30. I'm gonna put this over here. So we'll blow this up. This is why it can be a little hard to track, but I think if you have a civil case in a justice court, am I sharing this? Yeah. And it's not of record. I think it's this ORS 53030, which is within 30 days of rendition.
Okay.
Does that seem right? So that's why I'm really glad that we have everyone here today, because I certainly could be wrong about this. So one thing we need to do is to confirm what the standard is for civil cases from justice courts.
Yeah, the statute separate. Small claims are separate. There's a different chapter for specific small claims, which is where this difference comes in.
Yes.
Why it's 10 days in small claims makes no sense to me.
Yes.
Especially because you're not just the notice needs to be filed, but they have to deposit the full amount of the judgment plus the circuit court fees.
That's a question for this group about how we want to proceed with respect to the small claims. And it seems to me that there is some reason. So Judge Cross, you're exactly right that then there is a special statute for small claims actions. If you're a justice court not of record, it's this ORS 55110. And that is where we get this within 10 days after the entry of the judgment against the party. So the legislature created this special 10-day rule. I have not done additional research into figuring out what the legislative history is behind that 10-day rule. The work group should think about whether we want to maintain that 10-day rule. If we want to not maintain it, the work group should figure out whether we need to go and do that legislative history research and explain to the legislature, here's why you had the 10-day rule, but here's why it shouldn't exist anymore. What does the group think about? I mean, Judge Cross, I hear you saying this 10-day rule is too short to be viable or to be a realistic deadline for people who want to appeal in these small claims cases. What's, yeah.
I think I'm sorry.
Perhaps a more fundamental question is, why do the statute allow appeal from the small claims division at all when no appeal lies from the small claims division of circuit courts?
Right, right. And so what Jim is saying is true, that if your small claims case starts in the circuit court, there's no appeal at all. It says the judgment is conclusive. You can't appeal in your small claims case. I assume, Jim, and that the reason for the appeal is just because there's no record in the justice or municipal court, but that's a discrepancy. Like, you have a record in the circuit court, but you can't do anything with it. So why does it matter that you don't have a record in the justice or municipal court? What are people?
Pure speculation on my part, but because justices of the peace are not required to be attorneys. You know, individual counties can make it a requirement, like my county, it's a requirement, but it's not, but a county would have to decide. So there's many JPs who are not lawyers.
Okay.
And so and this is pure speculation, that maybe the notion was you could appeal from a justice court where a non-attorney was the trier of, was the judge and trier of fact.
Okay.
I have no idea if that's why.
Okay. Yeah, that makes some sense.
The other follow-up question to that, once the appeal is taken to circuit court, what is the status of the judgment rendered by the circuit court? Is it appealable like any other civil case, or does any appeal lie in a civil case rendered in circuit court? Let's say an ordinary civil case that begins in justice court that's appealed to the circuit court, and the circuit court renders a judgment in that civil case, can either party appeal from it to the Court of Appeals?
I think
Small claims are just generally, Jim.
Yeah.
Pardon?
Small claims specifically, or any civil case?
Civil cases generally coming out of
In
justice
general.
court.
I think there's one statute I saw that talked about when you go to, where it was in when you have a constitutional claim. So I don't know that there is any specific statute that says if you go from justice municipal court to circuit, that you go from circuit to Court of Appeals, but there's nothing that I saw that prohibits that either. And I know we saw some of those cases at the Court of Appeal. Well, yeah, I think we did see those cases that had come from justice to circuit to the Court of Appeals. But so that's something to clarify. And that's a big policy issue, which I'm going to put in the category of who can appeal what when. Like, that's towards the end. Like, can you go from justice municipal to circuit and then circuit to the Court of Appeals? If it's all right with the group, I'll put that in the category of those appealability questions that we'll take up later. But that's an important thing to keep in mind, is whether you can even go get the two appeals.
I think you can, Justice, in non-small claim matters, and civil non-small claims, because it's a trial de novo in the circuit court.
Yeah.
So I think this normal appeal, circuit court appeal routes exist.
Yeah.
And likewise, small claims, because small claims cannot be appealed from a circuit court, there would be no Court of Appeals option.
I think that is how that would work for the if you can go, like you can, from small claims to circuit court, then you stop in circuit court. I can't imagine that would be different. So a sense from the group on the 10-day limit in small claims.
So my initial reaction, and I'm not one to wish work on anybody, but the 10 days is an example of one of those things that seems to me pretty specific. And someone somewhere along the way said it needs to be specific here. I don't want the default to be that it was willy-nilly, which means that there may have been a thought process behind that that would be discoverable in that legislative research. And it seems to me that that may be an issue that comes up with a couple of things in these appeal statutes where you have these one-offs or something's one way when it may make sense to make it another way. And although it's more work to try to do that digging, it may be much more effective in being able to answer the question, well, why did this group change it from 10 days to 30 days? And why is this group recommending a change from an appealability issue if it comes from a justice court? And that applies to justice and municipal. So that's my knee-jerk reaction on Justice, your original question on how much digging potentially to do.
Yeah. I think if I were a legislator, I would want to know why it was 10 days and why you think it should be longer.
I guess my view is that if our goal is to simplify these statutes, that we ought to have a uniform 30-day appeal rule, regardless of the nature of the case.
Mhm.
The bill will, assuming there is a bill, it will be scheduled for hearing. And if somebody opposes the change from 10 to 30 days in small claims court cases, they can let us know.
Okay.
I guess that would be my view, is that if part of our goal is to simplify things, let's make them a little more uniform.
Okay.
And I agree 100% with that. If it were right now, I'd say 30 days for all, make it as predictable and easy as possible. Let's streamline all of this stuff. But I'd also want to, if someone asked me why, I could give them a good reason why we did this, but I'd also want to be prepared with the why the change from the prior thinking.
Okay.
I think one of the answers may be, as I'm, it may be that small claims court statute was part of the DD code. Who knows why they did something in 1860.
I guess we may find out.
Yeah.
Let me ask a question still related to the 10-day issue, which is this. The 10-day issue, the 10-day limit comes here out of ORS 55110. That statute applies to justice courts. I did not find any, and I'm not saying I am positive about this, but I didn't see any specific limit that applies to municipal courts. So my question for those of you with municipal expertise is simply, do you also handle small claims cases? And if you do, the work group needs to figure out whatever the deadline is for small claims, we might need to be specific that it's the same for justice and municipal courts. So first question, are there small claims in municipal courts at all? I didn't see a prohibition on those, and I did see some things that indicated that there can be some civil cases that come to municipal courts. Help me out.
I think the answer is that there is no provision for small claims cases in municipal courts because municipal courts do not have jurisdiction in civil cases. Only the justice court does.
Mm-hmm.
And we do not do any small claims at all. And I can't speak to the level that Jim can speak to or point to an ORS that says small claims shall go to justice courts. But I've never heard in any of my discussions with other municipal court folks, whether it's judges or folks who practice in municipal courts, or conversations with among those folks, small claims has never ever come up.
You don't have, great. Okay, so we do not need to worry about that.
Justice Duncan?
Yes.
I would like to make a comment in response to something that Jim Nass said. He used a magic word that caught my ears, simplify. And I think one of the reasons that we're having this whole bit of work is because what we have presently is complex. And it seems to me that unless there's an overwhelming reason found in legislative history, everything ought to be the same with respect to small claims in whatever court you're in, justice, municipal, circuit, whatever one. And that the time for an appeal, if any, I think it ought to be eliminated. It is, you don't have a right to appeal when you're in circuit court on small claims. Why should it be different for municipal or a justice court? Or pardon me, a justice court, because as Jim said, you don't get to do these in municipal courts. So, and by the way, just an overarching concept from the famous case of Shoeless Joe Jackson, it may not be so famous everybody knows about it with nods of approval, but Sandy does. You don't have a constitutional right to an appeal,
Right.
period. And why not use the wisdom of that guy who was convicted of shuffling? Why don't we just make it simple? You don't get to appeal, because I don't know any lawyer that does small claims cases, and I don't think you can do a small claims case as a lawyer unless you're a plaintiff. And there are not very many lawyers that specialize in representing small claims people. They're not going to make any money because the claims are small.
Mhm.
So I just really think simplifying all this is a really, really strong motivating factor to try to unravel all of these strands of spaghetti that have been thrown against a white wall.
Yeah. Did you have, so John, Henry, do I hear you saying like no, you would say no appeals from justice courts in these small claims cases? Do you have thoughts on what Judge Cross was saying about, well, maybe that is there because there's not a necessarily a lawyer as the justice of the peace?
So what?
Okay.
You take your dice and you roll them.
Okay.
And, if you're in Malheur County, I think you can bring a small claims case in Malheur County Circuit Court, or you can forum shop and go to the Justice Court. But we shouldn't encourage that as citizens, not as lawyers,
Okay.
just as Oregon citizens having efficient government.
Okay.
And may I, to change the topic just a bit, and I'm sorry, but this goes to this drafting approach. Sherlock Holmes was pretty bright, and he said to Dr. Watson, it's a capital mistake to theorize before one has all the facts. And the drafting approach, it seems to me, of making it like civil cases, from a practical point, we don't know what the facts are as to how many cases are brought or appealed in justice or municipal courts. And most lawyers, from my perspective, and it's admitted criminal defense, most lawyers that are gonna have a case to defend in justice or municipal courts don't know anything about civil appeals. Okay, they are not people from Stoll Reeves and all that stuff who know all this stuff in and out. And Judge Cross can speak both from his practical experience and his judicial experience before becoming a judge. If you want to simplify this, don't try to get criminal defense lawyers following civil rules of appellate procedure, because they don't know them. And they're going to make more errors. So that's my approach on why not find out how many appeals are there, how many are civil, how many are criminal.
Right.
Try to make them fit so we don't have to have more traps for the unwary.
Right.
Sorry for interrupting and going to the top, but I just wanted to state that because I feel so passionate about not getting lawyers in a situation of doing malpractice.
No, the point on the approach is that like currently how it works for the statutory scheme across the board is the criminal appeal statutes cross-reference for circuit courts, cross-reference the civil ones. They adopt as much as they can that's appropriate. And then the justice courts will adopt as much from those other courts as is appropriate. So we're trying to have as much overlap as appropriate, but not, you know, obviously there's differences between the types of courts and the cases that can justify different procedures, but when they can be the same as they currently are modeled, that it would be good if we could simplify things. Okay. So we have, and we have identified issues with respect to whether you can appeal from small claims, and if you can appeal from small claims, how long should those the deadlines for small claims be? And right now, I don't think the draft has 30 days for, I can't recall right now if the draft has a small claims 10-day deadline.
The draft leaves 55-110
alone,
except it does say it doesn't matter whether the justice court is a court of record or not. That's the change, and that's on pages 4 and 5 of the draft.
Okay. Any more thoughts on the timing for 30 days, generally 10 days for small claims before we move on to the triggering event for the notice? Hearing none. The triggering event, we have a difference in phraseology in the current statutes, like I mentioned. The triggering event is sometimes described as the entry of judgment, and then it's sometimes described as the rendition of judgment. And the latter is usually in the justice and municipal courts, court statutes. The draft uses entry of judgment in the docket. And I have two questions about that. So I think the draft is correct to try and eliminate the rendition of judgment language, because rendition of judgment, it's not particularly clear whether that's referring to the issuance of a paper judgment or an oral proclamation of judgment in court or anything like that. And so the draft improves on the current law because it suggests that we use entry of judgment in the docket. And the question that I have for Jim and Jessica is the current statutes generally with respect to justice and municipal courts talk about dockets as opposed to registers, which is the phrase used for circuit courts. And so those of you, so Jim and Jessica and Judges Cross and Gill, any thoughts on why we call these records, your like logs? We talk about them as dockets in the statutes right now for justice and municipal courts. Is there any reason that we shouldn't use the term that we use for circuit courts, which is register, which has a statutory definition, just generally?
My reason was that we were changing enough things, and the concept of the docket is well established in both justice and municipal courts. And so long as we clearly define what the docket is, that it would be okay to stick with use of that term.
Okay.
One of the things that we found in once the legislature changed the statute so that appeals could be taken directly from justice and municipal courts of record to the Court of Appeals, under chapter 19, it speaks in terms of 30 days from the date of entry in the register. Well,
Right.
Justice Municipal Courts didn't have registers, and the concept of many courts did not record the date that they entered the judgment. They recorded the date that it was signed, which can be an entirely different thing. And so we had a period of educating the municipal courts so that they actually put in their dockets the date that they entered the judgment in the docket. So they have their established ways of doing things. And I guess that was just one battle that I didn't want to fight.
Okay, and I'm not saying we should, and I don't want to, import something that doesn't fit. And so Judges Cross and Gill, can you tell us, like, what do you call what we call a register? It looks like by statute, you guys call it a docket. What works for you for describing this triggering event that will make sense for your courts and your litigants to say, this is the event that starts my 30-day clock or 10-day clock?
I will jump in. I'm sorry, I had to step out for a couple of minutes, so I may have missed the introduction or the segue into this
Oh, sure.
conversation, but I think I caught enough of what Jim was saying to catch on. And I'll tell you, just in our court, Eugene Municipal Court, we don't ever refer to the docket in terms of whether a judgment has been signed and then filed. I still, and I suppose this is my circuit court still just sticking with me, the vestige of practicing there, but I still refer to it as the register. Our equipment here, the electronic equipment, has a register of actions. And so we've always treated I suppose what is being called a docket for municipal courts and justice courts as a register. And so whenever we go back to the date, we look at the register. Now it's all kind of a fiction because it all happens exactly at the same time. I mean, that judgment is signed and it's already in our register of actions. There's no delay whatsoever. So that part, for at least for our court, is a fiction. Now I can't speak for other municipal courts.
Okay.
What they do. So if it were to be changed to register from our court's perspective, that would be fine because it's one less term to work with.
Okay.
But that may be different in other municipal courts.
Okay.
And Your Honors, if I may, I think we in municipal court really refer to docket as more of a plain language schedule.
Yeah.
And then there's docket numbers associated with that schedule according to cases. And then, as Judge Gill just mentioned, we have, I think, what we would consider a register of actions. I think in our electronic case keeping, we call it notes, but for all intents and purposes, it's a register of actions.
No, we have, Ms. Franz, we have a register of actions in
Okay.
Tyler, but it's court facing. It's not
Outward
I don't believe
facing.
it's outward facing.
Okay.
And I was just going to add, this is Jessica. It was really Jim who made the decision about whether to stick with the term docket. I didn't make any changes to that. But if you look at section 3, what the draft does is just makes the definition of what the docket is extremely clear. And then on page 3, it just makes it very clear that the docket must have the date that the judgment of the court is signed and the date that it's entered into the docket. So as long as we're consistent with the term, from a drafting perspective, I don't see a problem with switching that to register, as long as we're really clear what is the register and what does the register contain as far as dates go.
Okay.
And I don't know if we've been correct about this, but this is, I mean, Judge Chartel was here for 25 years and I took over for Judge Chartel. And they just had like the simple logging of things in each case file was listed, supplemental court register /record.
Okay.
And so that's just the terminology that we've used here. I've never, to be frank, given it any thought as to whether it was correct. Maybe I should have. But that's just the terminology that we use. And as Judge Gill said, everything here it's entered the day that the order or the event or the action occurs.
Okay.
Um,
There is an administrative entry. So if somebody says, I need to file 30 days from the entry of this order or judgment in your docket or register, there's not gonna be any difficulty ascertaining what that date is.
No, it's gonna be, it's the day that whatever that was signed, so it's a judgment that's signed, the date of that sign is the date that it's entered with. I'm off the top of my head, I'm trying to think, is it possible that a trial ran late and so the judgment was signed at 5:30 PM and so the judgment wasn't entered until the next morning? It's possible. But it's gonna be so rare.
Yeah, and in circuit courts, they can be
Right.
different. You can
Very
be in court and there's a oral pronouncement, and then there can be a filing and an entry date, and those can all be different dates. But we can, like Jessica and Jim have done here, just be clear about what this register or docket is and make it a requirement.
Yeah, the reason it became important, it's probably been about 15 or 20 years, or maybe even longer, but there was a period of time when the judicial department experienced a severe funding crisis, as did the counties funding their circuit courts. And we were encountering delays of literally months, that the clerk's office was unable to get the judgments entered in the register. So a judgment might be signed by the judge on January 15th, and it wouldn't be entered into the register until February, March, or April. And so that's why it became important. And the parties don't necessarily know when the judge signed it. They can only know by looking at the register when it was entered in the register. So that's why the practice became in circuit court that the determinative event was entry of the judgment in the register. And I think we should stick with that concept. Whether we call it a register or whether we retain the term docket doesn't matter to me. So long as the rules are clear, that's the important thing.
Mhm. And so long as, like, as a practical matter, that is a date that a litigant could get from the court.
Yes.
Okay. And that's what we're requiring when the draft is, that this has to be entered into whatever we call it. Okay.
Yeah, I ran into early on in my tenure here, I ran into a problem where there was a traffic violation and defendant appeals it goes, it was right at the 30-day mark, but it was probably like day 29 filed here. And we sent it over, but the Turk said, well, we didn't receive this within 30 days. So therefore it's not timely. And I had to have a conversation with folks over there because it's filed here. It counts as being, perfected and filed properly here. It doesn't matter when you get it, quite frankly.
Which is a question that lies ahead of us too, about where you file. But yes, right now you file with the court in these cases from which you're taking the appeal. And as long as that triggering date is accessible, recorded and accessible, we're in good shape. Okay. Okay. Anything else on how we should treat the triggering dates for these appeals? All right. Let's move on to special deadlines. And by these, I mean the deadlines that exist in circuit court in civil and criminal cases when you have a motion for new trial, motion in arrest of judgment, or motion notwithstanding the verdict. I don't imagine those are particularly common motions in the justice or municipal courts. The statutes do provide for them, and most importantly, they anticipate that a plaintiff can appeal from rulings on those motions. But Jim and Jessica, as I understand it, we don't currently in the justice and municipal statutes have separate notice of appeal deadlines when those motions are filed. Is that right?
I think that's right. I'm less certain in misdemeanor cases prosecuted in justice and municipal court. But certainly as to violation cases, they are currently treated as civil cases. And I'm relatively certain, and I'm quite certain that there is no recognition of those kinds of motions that can be filed in civil cases. I mean, I didn't even know if those kind of motions can be filed in a civil case in justice court.
So let's hear from our justice and municipal court judges, practitioners. Do you see these motions? That's not dispositive because if maybe people just don't file them, but do they occur with, can you let us know if you see these motions?
Not typically.
Go ahead.
Ever.
I'm not sure I've ever, I don't know if I've ever run into the actual appeal on any of these issues. I know that we have the JAs, you know, sporadically, but nothing post adjudication there.
Yeah. So this is probably something that doesn't come up a whole lot. But I think the group will need to think about whether we want these. We need to specify the deadline for the possibility that these motions will be filed, because the current law does anticipate that, especially like if you had a criminal prosecution in either of the justice or municipal court cases, and then there was a motion in arrest of judgment, the prosecuting entity, the city or the county or the state, has a statutory right to bring an appeal from the granting of a motion in arrest of judgment. But it doesn't look like there's anything other than the 30-day deadline for that, which might run before the motion is ruled on, I think.
Yeah, the way it works in circuit court is that first of all, the motion itself has to be filed timely. But if the motion is filed timely, then the time to appeal is suspended until the trial court rules on the motion, or I believe it's 55 days from the date of entry of judgment runs, and then that's kind of like a deemed denied period, and that's when the 30-day appeal period runs.
Yeah. So if somebody files a timely motion for a new trial, your notice of appeal deadline could be as late as 85 days after the entry, I think. And so it's possible in some of these cases that the 30 days will run and you will not have any ruling on the new trial motion or the motion in arrest. So Jim and Jessica, is this something that you think we need to be concerned about? It wouldn't be difficult to provide for it, but it does stretch out the time.
I will say that cases in justice and municipal courts of record, of course, are subject to the appeal standards applicable to circuit courts. And I don't recall in any appeal from a court of record of there having been one of these motions filed that would have affected the running of the standard 30-day appeal period. Certainly they could be in misdemeanor cases, But also my recollection is it seems to me that there are relatively few misdemeanors prosecuted in justice and municipal courts, that mostly they deal with violation cases. Is that an accurate understanding?
Well, I'll jump in first. I don't know what if I understand the question is, aren't municipal courts a place where it's mostly violations? And as a percentage wise, we absolutely have way more violations that come through our doors. But to put that in perspective, Eugene Municipal Court has, or at least pre-pandemic, I don't know about currently, but I'd say it's probably still the same. We had the second most number of misdemeanors filed in our court than any other court in the state of Oregon, behind Multnomah Circuit. So that's Lane County, that's Jackson County, that's Marion County, that's Salem Municipal, that's all that. And I want to say the numbers hover between, and I might get this wrong, but it's still in the same ballpark. I'd say anywhere between 4,700 and 5,000 a year. So it's quite a few misdemeanors to process. And so do we have a lot more violations? Absolutely. But you're talking about bigger numbers overall, as opposed to just percentages of what you see. I hope that addresses what the question was, Jim.
Yes, it does. And that's very useful information. Is the Eugene Municipal Court a court of record?
No.
And certainly in my court, we do a lot of tons and tons of violations, and the cases that get appealed in the circuit court are usually violations. I think we do several hundred small claim cases as well a year, but I think that I can only remember one small claim appeal that actually went out of my court to the circuit court, and I think that's important. Again, the shortened time period, and the fact that you have to post the judgment with the justice court. We hold it in trust pending the outcome of the appeal. But you got to get all that done within 10 days. So I think that contributes mightily to the fact there's only been one in my 5.5 years here.
Okay. So on the special deadlines for these motions, I think what we just need to think about is whether we need to have these special, it wouldn't be difficult to just have the same deadlines that exist for circuit courts. There's probably no harm in having those special deadlines, but I think what we're hearing is, even though there's a lot of cases in which those motions could be filed, especially motions in arrest of judgment, those aren't particularly common motions in circuit courts. And probably even less common in the justice court. So we could add these special deadlines for the rare cases where they might be needed. And the state, so Melissa might want to think about this in particular, because the state, I think, is the entity most likely to be affected by not having a post 30 days, not having a deadline that reflects the possibility that a motion for a new trial or a motion of arrest of judgment could still not even be decided until the 30 days have passed. That's the potential problem, I think. So let's mark that, and we can think about whether we need to add those provisions.
This is Jessica. I just wanted to raise a little policy question, which is for, like we said, courts that are of record are treated as circuit court cases. Courts that are not of record, speaking specifically to the motion for new trial, if the appeal is a de novo trial in the circuit court, do we really need to have special deadlines for those specifically?
I thought about that, and I thought that might be why we don't have them, because why do you need to move for a motion for a new trial? Why do you need to file a motion for a judgment notwithstanding a verdict or motion in arrest? Because you can just go to the next court and get a trial de novo. And I think that works for plaintiffs. And then what I need everyone's help thinking about is the situation where it's the party that prevails on one of these post-verdict motions. So if the defendant files, let's just say, files a motion for a new trial and gets the new trial, right? So you're getting a new trial in justice court, or they get even, let's not do a motion for a new trial because then you have to have the new trial. But if a party files a motion in arrest of judgment in a criminal case, that means that the defendant has won that criminal case at the justice court or municipal court, and the state would want to appeal. And if that motion isn't ruled on until 31 days or later, the state, which would have the right to appeal, might not have even known that it needed to appeal within the 30 days. That's kind of the rare circumstance that I thought it might come up. It's like if the party that files that motion wins, the other party might end up being too late to file a notice. That was the best I could come up with. So if that's not right, or if somebody's got any other ideas, let's hear them.
Well, one of the reasons might be because the costs involved, right? If you, yes, you can get a trial de novo in the circuit court, but you have to pay money to get there. For example, if I try a traffic violation, currently in Washington County, your cost to file your appeal in the circuit court is $420. There's a filing fee and a trial fee, and they won't take it unless the defendant has coughed up that money in advance.
Okay.
They have to post that with their appeal, notice of appeal. So that might be one reason. And I can think back when I was years and years ago as a trial lawyer. I remember I tried a traffic ticket case in a justice court that was not a court of record, and the state rested its case, defense went on a case, defense rest, and then the judge just renders a judgment, makes no closing argument. I was like, what do you mean? I wanted to make a closing argument. You're denying me my right to, and so I got a new trial in front of a pro tem judge in that justice court proceeding.
Okay.
With a much better outcome,
Okay.
as it turned out. But anyway, that's an example. Just from my own practice days that comes to mind.
Okay, so they can come up, and there could be a reason why you would make them rather than just go on to the circuit court because of the expense of going on to the circuit court. Okay. So that may be something to think a little bit more, and possibly we might need to build in those special deadlines.
I don't think it's a bad idea to prepare for something like that. I think it would behoove us to probably include those special deadlines with some sort of tolling language similar to, I think, the 30 days from the date of entry into the, I think, register, we're calling it now, of the order being appealed. I think if we had some sort of tolling language similar to that, I think that would cover our bases, at least for those special circumstances.
Okay.
So that's just my 2 cents on it. Is even if it may not come up now, I think it would be in our best interest to prepare for the situation that it does.
I think it's unclear under current law exactly what one can appeal from in a violation or misdemeanor case. And one of the things that the draft bill does in section 16 and 17, at least with respect to justice courts, is in essence take the wording that's applicable to appeals from circuit court to the Court of Appeals in criminal cases and makes that wording applicable to appeals from justice court to circuit court.
Okay.
And that would include an order made after guilty finding, dismissing or setting aside one or more counts in the accusatory instrument or an order granting a new trial. So that I think is a fairly significant policy issue of whether the appeal rights in misdemeanor cases from justice to municipal court to circuit courts should be the same as circuit courts. And yet another policy question, whether those same rules should be applicable to violation cases, which currently are treated as civil cases, appealable under a different set of rules.
Yeah. Okay.
And Justice Duncan, I want to go back quickly to the question of why you wouldn't just have that appeal de novo from a municipal or justice court. And one thought, and you all correct me if I'm just missing something, I'm way out of the ballpark, but if a defendant files a motion for new trial and has good substantive reasons to do so, if that's granted, they get another trial at the municipal court or the justice court level. That doesn't take away their right to appeal de novo after that. So you're ostensibly looking at a third bite of the apple or further. So that would be an instance in where a defendant would want to file that motion, but then also may want at the same time not extinguish its right to appeal. And that's where I think Melissa's suggestion of a tolling language or something like that may be specifically oriented towards a municipal and a justice court.
Okay. This is all very helpful. Thank you, everyone. Maybe what we can go to now is this issue of late deadlines. And what I mean there is for circuit court appeals, there's a special late deadline for, in certain circumstances, civil commitments. Let's take that one first. Do your justice and municipal courts do any civil commitments?
No, we don't, we don't do civil commitments, and it's understood in Lane County that a municipal court isn't going to be that entity that does that. And there's been interpretation and argument on both sides, but I think everyone leans towards the circuit court is the court that admits, although this municipal court, any judge as a magistrate, whether it's circuit, justice, or whatever, has the ability to initiate the process.
Okay.
And we don't, my court certainly does not do that, to my knowledge, never has done that. So
Okay. And I guess our group could double check. I mean, you probably both, it sounds like Judge Gill, you have the authority to do, your court may have the authority to do it, but as a matter of practice, it's not done.
I don't know if, so it depends on what the actual process of the commitment is. I think that any magistrate has the ability to initiate the process, just like two-person, a magistrate.
Right.
There are a couple other examples. So that's specifically delineated in the 426 area. But in terms of the actual commitment,
right,
I don't think municipal courts have the ability, or justice courts have the ability to do that actual commitment.
So that's something we could probably just hopefully answer with a quick research question to see if that committing authority is specific and exclusive to the circuit courts. If it is, we don't need to worry about these late deadlines for that category. That
would be wonderful.
Okay. And the other category I think we should talk about is what I'll call the 90-day late deadline for appeals from circuit courts in criminal cases. Under current law, if you're appealing a criminal judgment you're the defendant and you're appealing, in certain circumstances, you can file within 90 days. That has to be when the deadline was missed and through no fault of the defendant, and there's certain requirements that have to be made or met. I'm wondering what the group thinks about having a 90-day deadline for appeals. And we're talking about criminal appeals from the justice and municipal courts to the circuit courts.
The reason for the 90-day provision is that the virtually uniform practice in Oregon is that different sets of lawyers, different sets of appointed lawyers handle trial court cases versus appellate court cases. That is to say, apparently no court-appointed trial lawyer in a criminal case wants to handle the appeal. And so if a defendant wants to appeal, the defendant has to make application to circuit court to appoint a different lawyer to handle the appeal. And our experience is that process of getting appointed appellate counsel often runs past the 30 days.
Okay.
And so that's the reason for the 90-day provision. I don't think there's a similar problem in justice and municipal courts, although I don't practice in those courts. So I'm not certain. But so I think the question is, do defendants in justice and municipal courts in misdemeanor and/or violation cases experience significant delay in having to obtain new counsel to handle the trial de novo in circuit court?
I have not heard any issues regarding that with regard to, but then again, most justice courts are not courts of record. So they go to the circuit court, and so they're handled in the same process that you just covered if there's an appeal beyond the circuit court. So I'm not aware of any, but I think that the reason is probably because it's just not dealt with in most justice courts. Now, some municipal courts with our courts of record may have different experiences. Judge Gill may be able to address that, but with justice court perspective, it's not something I've ever heard about. I can certainly put out an inquiry and see if anybody has had any issues in that regard. So that's what I can tell you.
Yeah, I think I agree with that. The process here in Eugene is that someone's convicted and they get their appeal rights, and they're all, if they're indigent, they have an attorney appointed to them, then that attorney will assist them in that appeal process, which is, for us, you go check out at the front counter. The front counter supplies that paperwork at any time, and then that's done. It's not clear whether the defense attorneys are actually continuing to assist these things, but they traditionally have. But once that is filed, then their role is over, and this thing is appealed to circuit court, and it goes de novo. Then they get new counsel. If they're appointed counsel, it'll be someone under, the local public defenders and Lane County public defenders, or whoever has the contract with OPDS. So there's that gap where they don't have an attorney, but I don't know if it's analogous to what Jim was describing earlier.
And it sounds like from that, Judge Gill, that's the filing of the notice of appeal is pretty simple. You go to the counter, you get your paperwork, you execute it right there in the same courthouse. And so that can be done pretty quickly. Should be done within 30 days. There's not this need to have a new attorney appointed to handle the actual filing of the notice.
Correct. Right.
Which is what Jim is saying, is that handoff can cause that 30-day deadline to be missed. So it sounds like we don't currently have a 90-day rule in the justice and municipal courts, and we probably don't need one.
Yeah, and from my experience, I think that's right. Melissa, just from your perspective and working with defense counsel across the table and these kinds of things, and Melissa's the one who's taking these up to the circuit court and continue to prosecute them. So she may see more of what happens on the front lines than I do. And so I think that's right, Justice Duncan. I would also, though, always consider the caveat that there may be a good cause piece out there somewhere that I'm not thinking of, that may come up after this thing, after the statutes are written.
Okay.
If I may speak to that, one of the things that the draft bill proposes is to address a difference in practice between appeals from justice and municipal courts versus circuit courts. In circuit court, the notice of appeal, the original notice of appeal is filed in the Court of Appeals, and a copy should be filed with the circuit court. In justice and municipal courts, the notice of appeal is filed in the justice or municipal court.
Mhm.
And that has led to sometimes loss of appeal rights, because someone in justice and municipal court of record, for instance, where the rule would be different. So I say, since appeals in justice and municipal courts of record are subject to ORS Chapter 138, and the original notice of appeal must be filed in circuit court. If you're not a court of record, the notice of appeal must be filed in the justice or municipal court. I think the rule ought to be the same. But what this draft bill does is say it's not a jurisdictional flaw if you fail to file in the right court, so long as you file in one court or the other. So the practice of simply going to the counter in the justice and municipal court, not of record, and filling out the paperwork and filing it right there might not work if we've changed the rule so that the notice of appeal must be filed in the circuit court rather than in the justice or municipal court.
Yeah.
But so long as we don't make it jurisdictional, ultimately that may not be a significant issue.
So, okay. And so that wouldn't mean that we would need to have the 90 days. It's unlikely we would need to have the 90 days wherever we're filing, and where the notice has to be filed is something that we're going to talk about too. But I know Melissa, Judge Gill was wondering whether you had any thoughts on, like, is this 30 days reasonable, whichever location we end up picking? Is that
In my experience, if a person has been listening when the judgment has been announced, and usually it happens right after they leave the courtroom as they file the notice of appeal.
okay?
Every now and then there's someone who thinks that it needs to be filed with the Court of Appeals, I think, and it ends up getting sent back. But for the most part, I would say 99% of the time people do it immediately following the pronouncement of the judgment.
Okay.
And I think it's right. That gets filed over in circuit court, and then they get they have their first appearance over there. It's already noticed, and they get their court-appointed attorney right after their first appearance. I believe that's correct. It could be that it has to be after their first appearance because they have to fill out the paperwork.
Anything else on late deadlines? The 90-day. Okay.
I do have one question.
Yeah.
So if we do, let's just say we keep the 90-day deadline in anticipation of a defendant who's filing an appeal from circuit or justice because they may file in the wrong court, or there's another delay issue that's justified. It seems like, just given the circumstances here on the front lines, that we need to consider that 90 days and what that good cause would be for those 90 days for the late. it seems like the burden also shifts to, I don't know where the burden lies. If the defendant files at the wrong court, let's say they file at municipal court, it seems like it's the burden on the municipal court to notify the defendant, hey, you filed in the wrong court. And same if they file in circuit court when it was supposed to be a municipal court, the burden would be on the circuit court to say, hey, you filed in the wrong court. And I think if you have that burden there, then you can keep that 90 days because it's reasonable that this person would get notice that they filed in the wrong court. If you don't have that trigger there, then it could be that the defendant files in the wrong court and never knows it because they thought they were filing in the correct court in the first place. I think that's one of the reasons why the front counter bit works so well around here. It's very streamlined, very simple. It's the lowest bar for any particular defendant.
Right.
To do it.
Okay.
Anyway, so that's just a concern and question on burden.
Yeah. Okay. So we're at 11:30. I think we've done a lot of work and exploration. What I have as issues that we could talk about kind of preliminarily or just to flag for next time is really what we have just been talking about. So we've talked about the deadline, but now we're talking about what we've started to talk about is the mechanics of this is what makes sense for the courts and the litigants as far as where the notice of appeal should be filed. Like Judge Gill was saying, it's easy for the litigants to just leave the courtroom, go to the counter, file the notice. And then what Jim was saying is that's different than how it works in circuit court, where you go to the appellate court that you're going to. So we have the issue of where you serve, the issue of what needs to be in the notice of appeal and where you file it. And then we also have issues about what's in the record, who creates it, who files those. Those are still procedural things and stays and undertakings that we'll need to work through. With leave of the group, I'd like to create another spreadsheets that cover those things so that all of you have that information about what the current law is. And then we can have these kind of focused discussions on, well, what do we do about the questions like the four we've covered here today. So if that sounds okay with the group, we can do that. Before I go and kind of look at all the statutes, it is really helpful for me to know how it works on the ground because that'll help all of us know if the procedure we put in the statutes is going to be consistent with what happens in your courthouses. So maybe briefly, Melissa, Judge Cross, and Judge Gill, if somebody wants to appeal out of your court, how do they, what's the notice look like? Does the court provide it? How does the case physically move? How's it transmitted to, and we're just going to talk about appeals to circuit courts. How does that happen? That'll help me understand that and propose the questions for next time on those issues. So I know, Judge Gill, you were just describing, you go to the counter. Do you guys provide a form? How does that form get to the circuit court? How does the file get to the circuit court? Those sorts of mechanics.
I think that's a great question. And I tell you what, I'm going to suggest that why don't I get a copy of the form that we have or the set of forms and we can email them to you with the written out process that we have. So you see exactly what a defendant would see in this situation. And then we can augment that with whatever non-written information that we have, or, like what's in our procedures. So you can look at that. So I don't accidentally leave something out here, but you have it sort of in front of you. That might be, I think, probably the most helpful, because the basic is, yes, we have the form, you fill it out. It's a really basic form, you sign it, turn it into the circuit court, and the process kind of starts from there. But to get you a copy of the procedures as well as the document itself, I think would be helpful.
Yeah, one of the things I noticed in the small claim statutes, there's actually the form for the, I think it's the form for the notice of appeal. anyhow, it's just part of the statute. And we have in the rules of appellate procedure, we have templates too. So we'll have those models as well.
In my court, it begins, by the way, no litigant against whom a judgment has been rendered leaves the courtroom without me explaining their appeal rights to them and what they have to do and what it costs, what they have to post with it. That's for a couple of reasons, first of all, that way I know that I've given that instruction and outline it for them. And then they would get a copy of a form at the counter as well to file if they wish to. But also I don't make the assumption that the people that are in front of me are 100% literate. I mean, there's the two most common denominators of folks who wind up incarcerated. Number one is substance abuse, but number two is illiteracy. So it's very important, I think, not to assume that folks are going to be able to understand a form just because you hand it to them in writing. So they get a verbal explanation from me to start with, and then they get paperwork.
Okay.
Question, how does at least in violation and misdemeanor cases, how does the representative of the city or county or state, that is the DA or the judge, the lawyer representing the city attorney, how do they get served with a copy of the notice of appeal? Does the trial court, does the justice or the municipal court take that on as a task, or does the person filing the notice of appeal have to get a copy of it and that person is responsible for service?
So in Eugene Municipal Court, we have carbonless copies. That's what the form is on. And so our office gets the, I guess, the duplicate underneath the original, and that's served upon our office.
And so then,
Go ahead.
oh, so when you say it gets served with a passive voice, who does that?
I'm trying to, I believe the court gives it to us, or sometimes the defendant just hands it directly to us. That's happened to me in court. Maybe Judge Gill can chime in. If they file it with the front counter, is that just put in our box to be served on us?
Fascinating.
Yeah, the answer is, I think the technical answer is that it's the defendant that's required to serve or make sure that service is completed. The practical reality here is that we as a court try to lower that bar as much as humanly possible to make sure that the defendant can fit those rungs on the statute. And so the copies that Ms. Franz was talking about, getting the information to the DA and making it as easy as possible so that service can be considered complete. That's the practical reality around here, because we want to make sure that if someone wants to appeal their case, that they have the absolute lowest bar to be able to do that as possible. So there's a difference between what's required in statute and then, the group effort to make it happen. And the city prosecutor's office is pretty good about being involved and wanting to make sure that that's, I think we have similar philosophies on that.
John Henry, can you share with us your experience, as assuming that you have filed notice of appeal from a decision of a justice court or a municipal court to the circuit court? What has been your practice?
Well, I've done it. I don't know what to say other than that.
But you take responsibility for filing the original notice of appeal in the justice or municipal court and serving a copy on the district attorney or city attorney, correct?
Yes, and one of the things that I do is I consult the statutes each time I ever have to do this, because it's just nothing but traps for the unwary.
Yeah, I know. One of the things that we ran into when we started getting appeals from courts of record is that sometimes no attorney appeared on behalf of the city, county, or state, that it was handled by the police officer. The only representative that the defendant knew about was the police officer who showed up in the courtroom, and so they served the police officer. And question was whether that was jurisdictionally adequate or not. I think we've eventually fixed that, but that was kind of one of those kinds of practical issues that certainly I am very pleased to hear what the practice of the justice and municipal courts is, that if you fill out the notice at the counter, that a copy simply gets passed along to the appropriate adverse party. That certainly solves a lot of problems.
Mhm.
Let me, I'd like to clarify my answer. The only time I've ever appealed from those lower courts was in criminal cases, never in violation cases. And
Right.
violation cases are traditionally handled by the officer who issued the violation charge. I don't know whether that helps answer the question.
Yeah, and that's correct, Jimmy, because the statute prohibits a district attorney or a city attorney from appearing in a traffic violation case unless the defendant has retained counsel. So it's and a statute authorizes the officer to try the case on behalf of the state.
But to go to John's point, right? The traps for the unwary in the violation matter, the demand for discovery in any violation is going to be on the city prosecutor's office. It's not going to be on the officer.
Sorry, Judge, go run that by me one more time.
The demand for discovery in any violation case will likely be on or should be on the city prosecutor's office, right? As opposed to the officer. Now, it may be forwarded to the city prosecutor's office, but that's the entity that's going to process the discovery.
Well, I think that's correct, because the statute that prohibits the city attorney from appearing in the trial, from appearing in court.
Mhm.
But it does authorize as I recall, the city attorney or a deputy district attorney to consult with on the case with law enforcement. Judge Giles, is my memory correct on that?
It is a mere, it's a quagmire. And yes, it does allow the consultation, and no counsel can't sit with the officer during a violation trial unless they're represented by a defense attorney.
Right.
We have an attorney on their side. But the officer isn't going to be the one processing a request or demand for discovery. I think, and I've never thought about this, so this is all off the cuff, but I don't think the officer would know the first thing to do if they were handed a notice of appeal, other than give it to the city prosecutor. Or their
court, more likely the court coordinator for their office, for their department, but.
or their
But that's where the discovery thing is very much a local practice, because in Washington County, the Justice Court traditionally, they would say you're not entitled to discovery, period, because you're not a court of record. That was historically the case with my predecessor. I ruled differently when I took the bench here, and I ruled that the state does have to provide discovery. But where the defendant is pro se, they do in fact file the discovery demand if they file one, and almost nobody does. But if they do, they file it with the law enforcement agency from which the citation was issued. It's just kind of the practice. Oftentimes, the district attorney's office, if they get it, will simply refer it. They'll either return to the defendant and say we're not involved, or they'll refer them to the law enforcement agency, again, from which the citation was issued. So you get these different local practices everywhere, which goes back to John Henry's apt term quagmire for the whole process. Now, if attorneys are involved, it's a very different thing, and then they serve it properly upon the prosecuting office. And when that office says, no, we don't do it, go talk to the cops, then that's then on those occasions, that's an issue. And if they come before me, the prosecuting office is not happy.
Could I make a suggestion? so that, because Jim asked a question about the practicality of how things are really working. I think both Judge Gill and Judge Cross could speak to this about whether it's possible, but I really believe that it would be very helpful to this group if we knew, say, in the last 3 years, how many notices of appeal were filed in the justice courts and the municipal courts, in civil, in criminals, small claims. So we know what the volume is. And I know that you're both part of the group of the Association of Municipal and Justices of the Peace judges, and they have a lobbyist. And if you reached out to that person, for instance, to say, hey, this group is considering a whole lot of stuff about what's going on. Could you tell us what the number of appeals in your court have been in the last, say, 3 years, and broken down in those categories that we've discussed, so that we can know about this now, as opposed to when we're at a hearing and we're all testifying in favor of this legislation, and then these people come and say, this is a non-issue because X, Y, and Z regarding these numbers of appeals. And that would get them more involved in this process, which would improve, I think, the potential for passage of anything that we recommend.
And I'll tell you, Jack, I think the total numbers are going to be very low.
That's what I thought, but breaking it down,
yeah, no,
I think it's going to be mostly in
that,
criminal cases.
I think that's an excellent idea, and I think it's an important idea. And it's I think part of the reason why the numbers are so low are part of the issues that we're trying to deal with here.
Because the claims are small, and small claims, they don't mess with it. And if, you know, well,
so I think the numbers would go up if we can do our job correctly. The numbers may increase, but that might not want to be the answer the legislature wants to hear. I don't know about that.
So I just think that would be helpful to everybody, and make all this hard work, because this is hard work, to make it pay off with the passage of something that is based upon informed facts, going back to my friend Sherlock Holmes.
I don't know, maybe I shouldn't volunteer this, but when I worked for the judicial department, we used to be able to break down numbers of cases by year according to the event code. So for instance, when there's a misdemeanor appealed to circuit court, it's appeal misdemeanor from municipal court. And there should be a way to reach out to my former office about getting those numbers. And it's really a matter of, it probably would take less than 5 minutes to do that.
You know, Melissa, that background is extremely important, because when you look at circuit courts, you could also look to the state court administrator to figure out how many appeals directly to the Court of Appeals come when there's jurisdiction to do that, because then we'd have both sides of it and we'd be much more informed.
Yes, I agree. I have an individual I'm hoping may join the group from my old office, that's in the Office of Legislative Affairs, but she should be able to access whoever the person may be able to pull those numbers. And so maybe I can reach out to all of them and see if they can pull those numbers for us.
And to the chairs, I just got, Melissa, thank you for sharing. I got that name yesterday, and we'll formally invite them as soon as possible.
And Justice Duncan, would the Court of Appellate Courts have the information as to how many then went from circuit court up to the appellate court?
I don't know if it is coded, and maybe Jim, you would have an idea if it's coded, like where it originated. I mean, we will know what we've got from the circuit court. I don't know if it would also have the information. We could search titles, you know, anything that's going to have city, but if it's just a state violation. I will look in to see what kind of data dive we can do in our system.
Yeah, I know that, I think there's a code that's entered in the appellate register for cases from Justice Municipal Court, indicating that it is then an appeal from that court. What I don't know is if after the Court of Appeals decides the case, if a petition for review is filed, whether the register of the petition for review would indicate that its source is a justice or municipal court. I
Okay,
doubt it.
yeah, can go to the Court of Appeals.
Would we want more than 3 years, considering the last two have been?
Oh,
Yeah,
I just
Not
picked that
normal.
out of the air because it flew by me. I'm not advocating for a number.
I just wanted to, when I reach out to them, just want to kind of give them a good number.
Yeah, I think if there's not a reason to, I think the further back we can go, I mean, if we can go 5 years or 10 years, I don't know how far we can go back, but a longer chunk would give us a better perspective. I do not think that these appeals are that common. But that's just an impression, and we need, like John Henry is saying, we need facts to back it up. And like Judge Cross is saying, that might be a low number because it's just so difficult to figure out what to do. So why don't we do this? We've got a lot of information about the chunk of the process that we talked about today. That's great. For our next meeting, can I suggest that we continue to focus on this notice of appeal, and think if those of you who are in the courts or everyone who's had experience with the courts can think about like just the process. So after you filed your notice of appeal, what's the record, who creates it, and who files the record? And then perhaps we can also talk about stays and undertakings. So that'll be our next chunk of work. Like what happens what are the mechanics of those stages, and what are the decision points for our group in connection with those. That'll be our next topic. Krista, we had talked about possibly trying to schedule our next meeting just so we have it on the horizon.
Yeah, with this group here, that'd be great. And I can.
If that's okay. I'm gonna look. I know Fridays are not necessarily good for Judge Gill. Any other days of the week that we should try and avoid for any members?
Judge Duncan, you're actually sharing your email right now. I don't know if you want to
Oh, okay, let's not do that. Open
Wednesday,
that up in a different window. Thank you, Cindy.
No problem. Dylan.
You'll see it for a second. It's gonna flash up here. I'm gonna move it out of that screen.
No problem. Believe me, I'm
Okay.
going to.
Okay. I'm gonna stop sharing am I still sharing a screen at all?
Yeah.
Okay. I'm trying to stop doing that.
I think I can stop you as well if you need, but
That'd be helpful. Oh, there's my email again. Okay.
or cancel. Hold on. All right. Hi, everyone.
Okay. Great.
the mornings are generally preferable for me. I usually have my trial docket every third Wednesday, but that can fluctuate.
And Melissa, while we're looking, thank you for connecting with that information. That's really going to be helpful. And from the judge's side, Dan, I don't know if you, I'd be happy to do that work that John suggested of working with the organization. Do you have a good name for who the best connection with your organization is?
Judge McDermott right now is the president, but he's retiring, and now we got, so it's gonna be can't remember.
Is there an executive director or any staffer who works for it?
There's not. It's a low budget outfit, you know, Patrick Singh is the lobbyist that John Henry was referring to.
Who is it, man?
Patrick Singh.
Oh, it's no longer Carl Meyer?
No longer Carl, no. But Patrick is, he's with one of the lobbying firms.
If you could send me Patrick's contact information, I'd be happy to engage.
I will absolutely do that.
You know, I just as a suggestion for history, you might
Carl.
be able to contact Carl. 'Cause
Yeah,
he'll know the history of a lot of this stuff and have a very good familiarity with it because he's lobbied very effectively in Salem on these issues. And the more of those people that we can get giving us input, the more ownership of what comes out of this group will be acceptable. And it'll
Carl
really
is-
help us inform us on what's going on, the facts.
and Carl is the municipal court judge in Kaiser, and he's certainly still very involved in things and gives legislative updates and so on at many of the conferences. And so he's you know, absolutely an excellent resource.
Dan, if you could send me their contact as well, that'd be fantastic. I'd be happy to reach out.
I will absolutely take care of that.
I'm gonna throw out some dates. How does June 30 look for people?
Bear with me, I've got to finesse getting on a different screen here.
Are we looking at the same time and time commitment?
We're flexible, and as I may have said before, I'm not a huge fan of really long meetings. So, but maybe we could make these an hour. I would prefer not 2 hours. I think it's easier also to find an hour slot for folks.
Justice Duncan, I'm clear that day if it works for you.
July 30,
Agree.
June 30.
I currently have a mid-morning commitment, but it could probably be moved if that's good for everybody else.
I have a small claim trial that's on my docket that morning at 10 o'clock.
Ooh, maybe we could all come. Just
But sure, we're still doing the small claims virtually.
maybe we could all come.
So,
In educational, it's to be research.
now you never know. We give them the opportunity to mediate prior to the trial, so the trial wouldn't actually start until about 10:30 at the soonest. But if we wanted to do like 10 to 11, I could push the trial time back half an hour.
Does
And-
1 o'clock work? Would that be better for you, Krista and Judge Cross?
Oh, 1 o'clock would be fine for me.
How about the other folks?
That works.
Okay, 1 o'clock, June 30.
Yep. I'll send out a meeting notice. I'll get that scheduled.
And I will try my best I'll send you an Excel version of whatever I have so that you can compare these statutes on the topics that we talked about, that we're going to be talking about. I have not figured out a good way to get that information in a readable piece of paper. It's just too big. But I will try and have all of that so that you can, in advance of the meeting, familiarize yourself with the current statutes on these issues of service and what's in the record. And I can cross-reference Jim and Jessica's draft too. And I will try and get that to you in advance of the meeting. And we will take those subjects up. So that is all that I have, except for great thanks for all of your participation and expertise in this field. And we might be affecting a small group of appeals. We don't know, but I think we are cleaning up our work can help clean up an area of the law and help the process between the courts flow well. So thanks, everyone, and we'll see you in the not too distant future.
And Melissa, I'll invite your colleague that you suggested to the next meeting. And if anyone else has any areas that you think can be represented, let me know, and we'll work on that too. Thank you, everyone.
Thanks, Andy.
Hey, and Justice Duncan, is